by using the address of the property, I am able to go to the tax office, verify the parcel ID number of the property, because that's going to need to go on the listing agreement. It gives me kind of a rough little initial legal description. Lot 4, Section 3, River C subdivision. Some tax offices do give you the sales history of the property. I know where I'm at in New Hanover County, it does. Brunswick County, not so much, but it will give me my source deed, and that's what you're going for. The most current deed of who it's showing the owner is. It can sometimes trigger if there's possible special proceedings files that need to be further examined, whether there's a foreclosure, whether it's a pending estate and things like that. I know some tax offices are extremely thorough and they'll tell you possible permits and just miscellaneous information. You're going to want to call the tax office before you list the property live and active to verify if there's any governmental special assessments, governmental monies that are going to be owed at time of closing for that. And the way to find it, honestly, Google's your best friend. So Google whatever county the property's in, tax office, and that'll get you kind of started there. You'll come to find out that as you use the counties over and over, you'll start bookmarking those things. So it makes it a little bit easier to find.
Yeah, I mean, you have tax websites for each county. You have like some of our MLSs offer CRS tax data, which pulls a lot of tax information from that. You have GIS systems, and a lot of times if you have a hard time finding it, you can go to the GIS for that county, search it, find the parcel, and you click info, and it'll have a link sometimes to like the tax property card for additional information or permits and those kind of things. So a few different resources.
Yeah. The one thing I will say with the CRS I find in our county, I don't know about your guys, I don't know about other counties, trust but verify, because I have found stuff listed in the CRS that's not matching 100% to the tax office. So tax office is going to be your most trusted resource. And please, I can't stress this enough. The tax office is also going to give you the square footage of the home, but do not under any circumstances rely on that square footage. It's just a good jumping off point, but you're going to want to have that square footage verified. For example, I'll use my house as an example. When I purchased my home, the tax office had my home as a 2-bedroom, 1-bath house. My home was indeed a 3-bedroom house, so it didn't account for that entire other bedroom in the square footage of the home. And if I had been an agent listing that home, just went with the tax office square footage, I would have been potentially subject to a good slap on the wrist by the real estate commission, because I would have under disclosed and been way off on that square footage. So trust but verify. That's kind of with everything we do. Register of deeds. After you pull the source deed or know the deed, you can go to a register of deeds search. One of the most important steps you're going to take is go to the county the property is located. Search New Hanover County Register of Deeds, Wake County Register of Deeds. You're going to be able to glean a lot of information from the Register of Deeds site, such as vesting, who owns the property, restrictive covenants. You can search your seller's name as a grantor in the Register of Deeds, and it will tell you potentially any mortgages or liens that are attached to the property. Sometimes you can find UCC financing statements. Those two are liens on the property. They're a little bit rarer to see. They tend to sometimes deal if your seller has put in a new HVAC system, if your seller has put in solar panels, things like that. That's just, those vendors are going to file what's called a uniform commercial, I forget the other word of that, and I apologize for that, but it's a financing statement that secures their lien on the property and does have to be disposed of at closing through proceeds. So that could affect the amount of money a seller will receive at closing, because they don't often think of those financing statements as something that have to be paid off at closing. You can also find miscellaneous recordings, instruments of combination. If a property has been, if a manufactured home has been what we call detitled and affixed to the land. You can find a notice of intent to affix. There's all kinds of miscellaneous things. Taking the time to do just a brief little search of the Register of Deeds can save you and your client from having big surprises. It could save your clients money. And it just, I got you, Michael. And it just makes you stand out as the real estate professional that you are. Yes, Michael.
When you search the Register of Deeds, the less you look for, the more you find. So if the guy's name is William and you just search for Will, it'll pull up any variation of his name that's in there, because if they add a period or they add a junior or they add anything else, it shows up as a different variation of that name in the Register of Deeds.
Great point. The indexing in the Register of Deeds is only as thorough and great as the human on the other side keying it in. So you want to search it different ways, different variations. So don't just assume that, like he said, William, oh, it's not William, it's indexed as Will. That can't be my guy. It can totally be your seller. So take the time to look. Taking the time to research that deed is going to help you determine who the current owner is and prevent homes having issues down the line.
And right now as we all know, we're having a lot of scamming with listings. So this is a great way to start verifying if you are, have maybe a red flag feeling of this may or may not be the correct owner. Deeds are a great way to start to figure out if they are the legal owner.
Correct. So when you're reviewing the deed, the things you're going to look out for is the vesting. Who is the grantee of the property? Your seller, at the time they receive this property, they're the grantee. This is the deed to my home, as you can see when I first bought it. On it, it shows my mother and my father-in-law and me and my husband. And we're as joint tenants with right of survivorship. So it's also good not only to know the names of the parties, but flashing back to pre-licensing school, the type of ownership can determine who needs to sign. We all know joint tenants with right of survivorship, any of those four on that deed, should one of us pass away, or all of us but one of us pass away, we just know that nothing enters into the estate of the people that passed away. The joint tenants with right of survivorship means the last person surviving gets that property. If it's tenants in common, which would have been another route we could have went, say when my father-in-law did pass away, his interest in his share of the property would go into his estate. And the reason we did it this way, just kind of as an example, my husband's one of 9. We didn't want, if something happened to my mother-in-law, to have to deal with 9 siblings to get this property that we were paying for. So knowing, and then tenants by the entirety are typically husband and wife situations. So not only knowing the full names of the people, but understanding the type of ownership they have in the property. And then sometimes verify the percentage of ownership. I've even seen deeds where it's like, if Caryn and Lauren bought a property together, Lauren owns 45% share of the property, Caryn owns 55%. Lauren can't go out and just unilaterally sell the property, but she can deed her 45% interest. So it can get tricky in knowing what you're dealing with. And when in doubt, consult your attorney, consult your BIC. And then this one, number 4, nails a lot of people. Marital status. How many of you guys have ever worked with an out-of-state buyer or seller that when they purchased the home, they were unmarried or they purchased it solo, and all of a sudden they're blindsided by the fact a spouse has to join in on that sale? And we're going to talk about that in just a minute. So kind of keep that in the back of your head. And then review the legal description for any subject to terms, limited life estate interest, restrictive covenants, exceptions, right of first refusals. Sometimes you can have less than accepting. I'm going to sell 1.5 acres, less than accepting that half an acre. So knowing what's within that legal description, mine's pretty straightforward. No surprises there. Any questions about this so far? And if I go too fast, please definitely stop me. So understanding marital interest is key. In North Carolina, marital interest in real property is the legal right a spouse acquires in their partner's real estate, regardless of whether their name is on the deed or not. Even if the properties, and this is an important distinction to know, even if the property is acquired by your seller before the marriage or through an estate inheritance. If my mom passes away, I'm set to inherit her house. Guess what? If she passes away while I'm married to my husband, he has a marital interest in that house. Pro tip, you hear all the time, 1 to buy, 2 to sell. That's true, and it's not necessarily true, all in the same. Whenever there is a conveyance of interest in a property, you have to have the non-borrowing spouse involved, unless sometimes attorneys can skirt around it with a purchase money mortgage and make that argument. But not all lenders and not all title companies are on board with that. So when I'm signing a deed of trust, I'm signing over an interest in that property to the lender. So some attorneys do require not even non-borrowing, non-title holding spouses to sign a deed of trust. So just have that conversation when you schedule the closing, so that if they're coming into town, one spouse comes into town, leaves the other back in New York, and all of a sudden you can't close because the other spouse needed to be there and wasn't. So just having those conversations from the very beginning just save a lot of headache and heartache there. Any questions, Michael?
I actually ran into this in a listing appointment yesterday, and I've run into it several times before. Both names are on the deed. You show up and they say, oh no, I divorced her. I got the house in the divorce. But they don't understand that the judge said that's what happens and that's the right. But without the deed being filed, the quitclaim deed, the other signature is still needed.
Yeah, you have to file because I was going through a divorce, and yeah, had we kept the house, because we were debating whether to sell it, like me just take the house or sell the house. Had we kept it, I would have had to do a quitclaim deed to get my ex-husband off of that deed through and have it noted in our separation agreement. So I would have the legal documents. So when I went to sell it, I could prove he had no marital interest.
Looks
Also,
like
I
Caryn was all
purchased
set up to explain this already.
Also,
it's
I
great to
purchased the
mind.
home while
Teamwork.
still legally married, legally separated, but legally married. So you're like, well, how would you do that? Because he would technically, I bought it while married, right? Well, you then had to sign a free trader agreement to relinquish and waive all rights to that property. But I have to have that document whenever I go to sell this house to prove that he waived all his legal rights to the property. So there's a lot of things when you're in those kind of situations to make sure they've gotten documented, or you might need to have some lawyers involved and have people start signing things.
Now, Lauren, hang on, I'll grab both questions. Lauren mentioned a free trader agreement. What a free trader agreement is, it's drafted by an attorney. It allows a married person to act as a single person, independent and outside of that other person. This deed that I'm showing you, this was the prime example of what Michael was talking about. This is a quitclaim deed that my seller was married when he bought the property. They bought it together as a married couple. She quitclaimed her interest. The caveat I will say about this deed right here is it's presented. If they were married when she signed this deed and there was no free trader agreement, she would have terminated her ownership interest, but she wouldn't have necessarily terminated her marital interest. So on a quitclaim deed, when they're married, it has to have two things. One, they're signing over their ownership interest, but there's a little paragraph that an attorney will insert into the legal description. It says pursuant to North Carolina general statute, and I forget the statute number. The grantor acknowledges they're terminating also any marital interest or claim they have into this property. So if this deed had been given to me at the listing appointment, hey, we're still married, but she signed over her ownership interest, I would be like, that's fantastic. What about her marital interest? And then we would have had to start kind of working on that at the initial listing appointment. If they had both produced free trader agreements, I would have had some more questions for them. Shelley, you had your hand up first.
So I had a fun situation where I'm showing a single guy some properties. I'd ask him, are you married, divorced? He says, I'm divorced. And so we went forward with that. Turns out he had signed his divorce papers. She lives in Ohio. He's in North Carolina. She never filed them. He was still married. So If they say I'm divorced, I'm going to start saying I need to see your divorce decree.
And if they get married during the transaction, that could change things. So if they start out as a single person and he just goes, oh, Shelley, I'm single, but by the way, I got married last weekend, we got to start asking the lender and attorney questions. Does the new spouse need to be involved? Kristen, you had a question?
I did. So if someone buys a property before they get married and then they get married a year later, is that interest, it's just for that original person that bought the property? There's no spousal interest in that, right?
No, spouse has interest. So say Michael has 10 houses, one of them is a $10.2 million house. And Michael bought them all by himself. And then Caryn comes on the scene and marries Michael. And Michael's had these houses 1 year, one 5 years, and one 10 years. The day that Caryn and Michael get married, Caryn has an interest in all of Michael's houses, unless I've signed a prenuptial agreement.
Gosh, that is not what, I mean, that is just not what they told me in my class, which is really interesting. I'm glad that I've heard this now.
But different states are
ways
different.
that people could write
Right.
stuff with quitclaim deeds, free
Yeah.
trader agreements.
You can get around it, but-
Prenuptial agreements, but overall, without sending any other legal documents drafted,
Okay,
there's marital interest in everything. North Carolina's a 50-50 state.
Yeah.
okay.
And
And it
if you're
trips a
working,
lot. I'm sorry, go ahead, Shell.
if you're working with somebody that knows what they know in a different state, then you just have to educate them on how North Carolina does our things. And that's one of our biggest hurdles with living at the coast, people relocating, people buying investment property. They may know their real estate law in their home state, but North Carolina is that 50-50. So we have to be very clear that they understand who is owning that property if they're married, even if,
And not every state has marital interest. This is just something very unique to North Carolina, and it trips up a lot of buyers and sellers. Michael, did you want to add something?
I did. I wanted to say, I've run into these cases before where I knew that this is exactly the way that it was, and it got to the attorney, and the attorney told me that I was wrong. It was something else. Don't argue with your client about this. Tell them what you think. Make sure that they understand that we're going to have to get the attorney to look at this when it goes through title and the rest of the process. But don't tell them they're wrong and you're not divorced and you didn't do it right in the paperwork. Let the attorney do that. That's not our job, is to make them aware of it, not to prove to them that they're wrong. If you're stubborn like me, don't do that.
Right. You just have that conversation. Hey, heads up, the attorney may require them to sign, and we're gonna work on that while we got your house on the market. So don't be shocked or surprised if we have to contact your spouse or your potential ex-spouse just to get them to tighten up some paperwork. But we're going to work on that on the back end. I just don't want you to get all the way to the closing table, sit down, and someone go, well, where's their spouse? Like if in Lauren's case, they said, all right, Lauren, where's your spouse? And then she's scrambling to find wherever her ex-spouse, because some of them don't talk. Some of them it's so contentious, they don't talk. So just be mindful of that. There's other ways to own a property through estates, special proceedings. You can be a corporate entity selling a property. You can be a trustee of a trust. You can have a right of first refusal, and you can have lifetime rights to a house. And we're going to talk about those. So estate files. Estate files are fun. Everyone of them is different. The important thing to know in an estate file is the first question you ask. They say, I got this, my mom passed away and I inherited this property. Okay, sorry for your loss. Did your mom die with a will? If she died with a will, you're going to want to see a copy of that will, just to make sure it spells out who the heirs are, who inherited the property, because they could have 10 heirs and only one of them be entitled to the property. If they don't have a will, sometimes having the letters of administration from the estate, and this is an example, this is an actual one that I closed. I redacted everybody's name, but luckily I had this application for letters of the administration. It labeled all of the heirs so that I knew who needed to sign what, and know the and make sure you know the status of the estate file. Is it open? Is it closed? And the estate file is always going to be filed in the county the property is located in, even if the person died somewhere else. It should be opened there. That doesn't mean it always is. And North Carolina, in their infinite wisdom, know that we are not the best with estates, and estates are inherently confusing. gave us this estate flow chart. So when you're meeting with a client, they say they're in an estate, start asking these questions. Did the owner die with a will? If they did it with a will, you just scooch over. Is the estate file open and closed? If it's open, only, and it tells you who needs to sign, only the beneficiaries in the will. The beneficiary spouses, catch that, marital interest again, and the executor of the estate should be named as seller on all agency agreements, disclosures, and contracts. If they died without a will, then it goes back, is the estate file opened or closed? If it's closed, you go this way. If it's open, here. So thankfully, they gave us this lovely estate flow chart so we know where within an estate file who needs to sign what. And this is found, I pulled it off of NC Realtors. I'm not sure if it's in our .loop, but it's in NC Realtors if you log in your NC Realtors account. Any questions, add-ons? The fun part of mine, it got even better. One of these, this one here, this estate here, the one daughter here was the executor and the heir. This son here had a guardian appointed. And so I not only had to deal, because he had an intellectual disability that we had to address. I had a guardian that had to approve everything we did and subjected it to a 10-day upset bid period. And then this daughter was married. So it was a lot of fun dealing with marital interest, a guardian appointed, an upset bid period, and an estate all rolled into one fantastic transaction. I use it as a lot of my teaching because it's like everything in the kitchen sink was in this transaction. And it was a historical home in a flood zone. So it just like, it ticked every single box of fun things that you have to deal with when you're listing a home for sale. All right, so corporate, if you're dealing with a corporate entity, that can happen. Like when I purchased my home, I purchased it from an LLC. The thing to know with that is if you go to there's the website there, www.sosnc.gov. That's the Secretary of State for North Carolina. You're going to want to go there and you're going to want to search that entity's name to find out sometimes and view their filings. It will tell you who is affiliated with that LLC, with that corporation, so that you need to know who needs to sign. Typically, those LLCs and corporations need to be active and in good standing. So if you search at the Secretary of State's office and notice that it's been administratively dissolved or it's inactive, you got to get an attorney involved. Because the one I dealt with, fortunately, it was being administratively dissolved by the members of the LLC. The attorney and the title company agreed that they would allow the LLC, while administratively dissolved, to sign the deed as processes of wrapping up their business. And there was a caveat in my deed about that they signed this to wrap up all the business and close out the LLC. Michael, Lauren, anything you guys want to add about corporations?
Just that sometimes the signatures get funny on the forms, but come talk to us about it. We'll help you with it.
Yeah, it's trying to set it up in .loop. It can get a little wonky and fun. So definitely. And when you're putting an LLC, just make sure you name the corporation and then go down on the corporate signature lines. Not it'll want to put the corporate's name in on the signature line, and it can't sign ABC Corporation. You have to sign it John Smith, president of, or member manager of. You had, Oksana, you had a question?
I do have a question. I find it really very informative. Can we receive this presentation after?
Yeah, of course. I'm happy to send it out. It's in,
Yes,
I don't know
please.
if he has Canva.
Then I won't make snapshots all the time, okay?
What I'll do is I'll print it as a PDF booklet and email it. I'll email it to your Bix, and then that way they can circulate it out to you guys.
Great. Thank you.
Of course. Trust files. The fun part of trust files, as you can see, it's like you need to review, you need to request the seller. If the seller goes, hey, this is in my revocable trust, we're going to be selling it in part of the trust. You're like, that's great. That's wonderful. I need to see the portions, not the whole trust agreement, because sometimes those things are 55, 65 pages. You just need to see a couple of portions of the trust. You need to see the portion that identifies who the trustees are, and the portion that shows their authority to convey the property on behalf of the trust, to sell the property. It's only two things you really need. Typically, attorneys require a memorandum of trust to be recorded either at closing or prior to closing. If they don't have a memorandum of trust filed, a lot of the times the attorney representing the seller will prepare that as part of their deed documents. And when you're setting up the signature lines on the documents, it needs to be signed by the trustee for the trust, not just, it doesn't need to be signed like this one here, Delona Eccles under Hilda Eccles Revocable Trust. You don't have revocable trust on, being signed. It has to be the individual person. So in dot loop, the signature lines do get a little wonky, and sometimes you have to unassign stuff and reassign stuff. Yes, ma'am.
A quick question. I know these aren't usually public, but what if someone's not willing to give this information up? Where do you go to find it or verify who actually has that?
You can't verify a trust. They have to give it up.
They have to give it up. Okay.
And sometimes you can make the attorney be the bad guy if you need.
Okay.
And
Okay.
tell them, I'm just asking for this. I'm asking you for the things I know the attorney's going to ask you and I for. So let's
Okay.
jump on it.
Okay. Gotcha.
Hate to get all the way down, pay for marketing photos, pay for floor plan renderings, get a contract, get it under contract. And Shelly's like, oh yeah, I'm the trustee of the ABC Trust. And she signs everything, and due diligence money's paid, and we're days from closing, only to find out that it's Lauren Greer that's the one that has to sign, and we can't find Lauren because she's in the Swiss Alps for 3 weeks living her best life, and Shelly never had the authority to enter in any of these agreements. That's kind of that's why you want to verify. You trust but verify. So if they refuse to do it, say, are you willing to give it up to your attorney? And then you just say, let me put you in touch with an attorney. And you get the attorney early in the process, earlier than you normally would in the process, but that's a great question. And then understanding the right of first refusal. Has anyone on here never heard of right of first refusals? Okay, so we have a closing right now, and it's very popular on the coast, especially when you see boat docks and marinas and things like that, because they're hard to come by. So a lot of the times the developers in their infinite wisdom will reserve what's called a right of first refusal, which means if I'm going to sell the property, that developer, that builder, whomever has that right of first refusal gets the first dibs at that property at that price. So if there is a right of first refusal, you have to get something in writing from them declining, waiving, terminating I'm not going to exercise my right of first refusal, and I'm going to just pass on it and allow it to close. So start those conversations kind of early with whomever has the right of first refusal. Because they could come in and say, oh, you could come in and say, hey, I have a contract for $10,000 on this boat slip. Shelly, are you going to exercise your right of first refusal? And Shelly's like, 10 grand. Heck yes, I am. And then now Tony's buyer's super pissed off at Tony because the developer exercised their right of first refusal because Michael never told Tony there is a right of first refusal out there. So if there is a right of first refusal, I would say disclose it in agent notes, disclose it everywhere. You never get in trouble with the real estate commission for over disclosing something. It's only when we under disclose or fail to disclose, the real estate commission is going to look at us. Any questions on right of first refusal? But it is an interest in property that has to be terminated prior to closing, exercised on or terminated. And then this is kind of how it usually works. These are just samples of listings. So anybody on the call that wants to buy 733 Laguerre Lane, it is for sale in our office. Please see me, Shelly, Lindsay Jenkins, any of us. But the owner can list the property. You can even get an offer from a buyer, but you need to tell that buyer agent there is a right of first refusal we have to deal with. Before accepting that offer, the owner must give the right of first refusal holder the option to match the same price and terms. This is where it gets a little tricky because we're not supposed to disclose anything in a buyer offer without buyer's permission. So please make sure you're getting all the adequate permissions. Hey, Tony, so great you gave me an offer on 733 Laguerre Lane. I've got to deal with this right of first refusal. Can I have permission from you and your buyer to release the terms of this offer so we can at least try to get this thing terminated? That way your client knows whether they can move forward and buy it, or if we can at least get that right of first refusal terminated so it can clear for your client. So get that permission in writing. If
So I've
you,
never actually dealt with one of these before.
it's fine.
But if the buyer client didn't give you permission to disclose, then you would have to just
you're at a
decline their offer because you can't honor it.
It's a standoff. So if Tony told me, no, you're not disclosing my buyer's offer, then I'm going to be like, then we have a problem, Tony. I can't move your offer forward because that right of first refusal is going to sit there and stop you and I from moving forward. So unfortunately, I have to release those terms. So yeah, but I wouldn't release them without permission. Or you say, hey, Thomas, it's great. You're submitting an offer. Just know that any offer I receive, your client has to be comfortable with me releasing those terms to the right.
Do you find this in the deeds as the listing agent? The listing agent ideally knows about this and has put it somewhere, but
it can be in the deed, but you can also be blindsided through the HOA, because I've had that happen too before, where it was never in the deed. And keep in mind, the deeds are only as good as the attorneys typing them and the paralegals they're supervising. And if they forget to put subject to a right of first refusal in a deed, and it just kind of the train keeps going down the tracks, you may not know it exists until somebody's doing a title search and we already have an accepted offer, because that's what happened before. Lindsay and I had one completely under contract. No one continued the right of first refusal in the deed. And it was when the title search was completed by the attorney's office, they found like 2 or 3 deeds back, there was a right of first refusal by the developer. And that kind of upset everything and had to pause everything. Lindsay and I had straight up anxiety and heart palpitations till we knew the developer wasn't going to move forward, because the buyer had already went through with like inspections and appraisals and all that jazz. So yeah, so that's why if you're the listing agent, looking a couple of deeds back is not a bad idea either. I know you're not hired to do a full-on title search, and you're going to know a lot of the times right of first refusals are mainly on very unique properties, boat slips, boat docks, things along those lines. If it's a more rare or unique property. And then you put it in, God bless Debbie, who's on this call right now. Debbie does Lindsay's listing paperwork. She's her admin assistant. So get a good admin and assistant as you get busy. Debbie typed an Exhibit A to the listing agreement, which you can do under your BIC's supervision as long as your BIC approves it. And it says right there under the Exhibit A, right of first refusal will apply to the transfer of the boat slip, and terms can be found in Article 2. See, that one was found in the master declaration and recorded.
Oh, Jesus.
So it's always good to just kind of double check that stuff. All right. And then understanding life estate interest. You can have a deed sometimes that is subject to the life estate. So if my husband buy a house and we give my mother-in-law a life estate interest, but because my mother-in-law is living in the house, and we go to sell the house, we have to have my mother-in-law join in on the conveyance, conveying her life estate interest over to the new buyer. Life estate tenants, when they pass away, their life estate interest automatically terminates and the property goes back to kind of the remainderman or reverts to whomever is written on the deed. So if me, my husband, and my mother-in-law buy a house, we only give her life estate interest only in the property, and she passes away, her interest in that just automatically reverts to my husband and I, and he and I are free and clear to sell that property. You'll find that life estate interest referenced in the deed itself. They'll be referenced as a person. If you're listing a home and there's a life estate, have that life estate person either join in on the listing agreement or have the seller and the life estate person execute a quitclaim deed to get that life estate interest terminated before you list. So the life estates are a little bit easier to deal with, but they still exist. It's mainly done, this is kind of a comparison of them. This is the life estate. It's limited to the lifetime of the tenant. They hold present interest. life attendant may use, occupy during their life. They can only transfer their life estate interest. And life tenant can mortgage their life interest, but that's it. Lien ends at death. And it's extremely rare. I've never seen that before where they mortgage. I cannot will my life estate interest to another person. It kind of dies when I die. So. And then special proceedings files. And if I'm going too fast, stop me. I'm trying to fit all this in an hour for you.
Those I don't like.
Special proceedings, you'll see foreclosures. It's always good to know if a property is pending a foreclosure. Partition sales, proceeds to divide a property. If co-owners refuse to sell, which I've seen in estates, there could be eminent domain, there could be evictions, there could be estates, and there could be guardianships. The way to know, you're not going to always know if there's a special proceedings file. But if you needed to access a special proceedings file, you're going to visit the clerk of courts, or the easiest way, honestly, if you have a good relationship with an attorney, call them and say, hey, can you pull, with the next time your title searcher, your paralegal, or somebody's at the courthouse, can you pull this special proceedings file and pull some documents out of it for me? So, but they're always located in the county where the property resides, even if the sellers reside elsewhere. And it's rare that you have to go deal with special proceedings files. The most common one would be like estates. And then other things you have to look at when you're looking at the deed: legal descriptions, plats, condos, restrictive covenants, rights of way, access, manufactured and mobile homes. And Michael, I'm going to tap you on the manufactured mobile homes. But when I'm listing a home, I always look at the plat map, and I have gotten to the point that I upload the plat map as part of my MLS documents, even though the clients can find them in the MLS. I might find them at the Register of Deeds, because I want whoever's looking at my property to know that I have disclosed that 30-foot drainage easement that's on my lot. Or so I just don't want there to be any questions whatsoever. And I don't want anyone to ever come back and say, Caryn didn't disclose that. I've put it in the documents for you. If your agent failed to notify you, I've done my duty. I've done my duty to my seller to disclose all of what I know. And then reviewing the legal descriptions. Sometimes the legal descriptions will give you the map book. It'll give you restrictive covenants. I know trying to get restrictive covenants from an HOA, you would have a better luck in winning that mega Powerball multi-million dollars. The HOA companies are virtually impossible to deal with, but unfortunately we are required to deal with them. And getting the documents from them, I would say to your seller, in the event we have to get documents from your HOA management company, you may have a fee for that. Some HOAs charge up to $250 to $300 to give those documents to us. And so just be mindful that could be a charge you would incur, Mr. Seller. And then legal descriptions. I'm using this one as an example. This was the deed, and I meant to flip these or take that out. This was the deed into my son when he purchased his house at Asheville. I'm going to show you this because just because we're licensed all over the state does not mean we should be necessarily licensing, doing real estate all over the state. But he and Hannah bought this. They worked with a Coldwell Banker agent. And at the time, this was their legal description of their deed. Nowhere in it, it just talks about the restrictive covenants. So if you're representing a buyer, get a copy of those restrictive covenants, show it to them, review it. But if I were listing this home, I would list all of those restrictive covenants. I would say skim them, definitely skim them, because in my son's restrictive covenants was this: no dogs allowed in the condominium unit. Each unit shall be allowed to have one cat. So he was living in a dog restrictive community and he had 2 cats. So when he bought the house, that was his pets. He had Layla and Sushi and Ernie, and the realtor knew it. The realtor knew they had a dog. It was not a service animal. So after they close, after they move in, the HOA steps in and tells them they need to get rid of their dog or move out and sell their home. That can happen. So if you have a client that's like, oh, Lauren, I want you to represent me in my sale, and I am so looking forward to having 15 chicken coops and all the chickens in the world because I love eggs. And Lauren shows me a house and it has restrictive covenants that doesn't allow for chicken coops. And I buy this house only to find out that I can't have my chicken coops. Because that's a material fact I've disclosed. That's what I want more than anything is them chicken coops. Then you could get in trouble through the real estate commission. Not to mention if they had to resell and took a loss on that property, it could get very messy for you as the agent. So having those initial conversations with your buyer clients, I know we're jumping around a bit, but as the seller, if I'm listing this home, I'm going to take the time to skim those restrictive covenants for things like this, because I would have listed the home and disclosed this is a dog restrictive community and pet limitations. So then I've disclosed it, I'm okay. Because I told Cameron, I said, you could have filed a claim against your agent and the listing agent, because the listing agent failed to disclose as well that this was a dog restrictive community. Any questions about that? And this is my favorite, septic permits. I don't know in Raleigh, Wake County, do you guys have septic permits a lot?
Yes.
Fayetteville,
We have a lot of them.
so septic permits are my favorite thing in the world. You need to pull these as the listing agent, contacting the Department of Environmental Health in the county the property is located in.
You need to pull them if you're the buyer's agent too.
Yes, thank you for that, Michael. Most definitely. I was going to go, you jumped ahead, but I love it. Michelle Robinson in my office went on a listing appointment, and the listing, it was a 5-bedroom house. When Michelle pulled the septic permit from Brunswick County, it was a 3-bedroom house. So guess what? She could only list this as a 3-bedroom house and had to adjust her value for the home accordingly. She couldn't give them the value bump for the 2 extra bedrooms. Now the seller could have come in and upgraded their system to a 5-bedroom, but they chose not to. So that's the thing. If you go into a listing appointment, hey, we're sitting on a septic, we have a 5-bedroom house, isn't it great? We added on 2 bedrooms. You're like, wonderful. I'm going to pull your septic permit. And then you have to have that conversation. You as a realtor are only allowed to advertise the home bedroom count for the number of bedrooms shown on your septic permit. And this one has 3. So even if it's a 10-bedroom house, I am only allowed to advertise a 3-bedroom house. Little pro tip here. If there's no septic permit on file, make a note in your file, print your email correspondence, put it in your agent notes. No, that way you've done all you can do to disclose. Put it in your .loop file, because a year or 2 down the road, if someone files a complaint at the real estate commission that Tony sold me a 5-bedroom house and it's only should have been a 3-bedroom, Tony can go, I did everything I could to verify it. I did everything an agent reasonably could do. The county didn't have the records, and sometimes the counties don't keep them that long. And like Michael said, if you're a buyer agent, I was a transaction coordinator for a buyer agent. I pulled their septic permit on a 4-bedroom house. Come to find out it was a 3-bedroom house. Per the septic permit, we asked for a price reduction for misrepresentation for that and got it. So
Yeah.
it's client money.
I've actually had septic done just to get an idea from the septic inspector what size the septic is, so that I could put in the documents, this is what, per the septic inspector, this is what he says, but there is no septic permit on file.
And so if somebody tried to file a claim against Tony for that, the real estate commission is going to come in and say she did everything reasonably that an agent could reasonably do to disclose. She didn't do anything unintentional or intentional. Yes, Michael.
I have on more than one occasion dealing with septics actually gone to the office where the records are held and gotten a different answer than I've gotten through email or on the phone. So if you're in that position and they tell you they don't have it and they tell you they can't find it, actually go to that office and talk to the people in person. Because I was selling a house that I helped them buy it and then I helped them sell it, and they upgraded the permit while they were there, and they showed me the receipt, and the county says, no, they never did that. When I showed up at the office, they found the records miraculously. but everyone else was telling me no over the phone.
I'm willing to bet that was in Orange County.
No, actually it was Harnett County.
I can tell you, Orange County is horrible. There's only like one person in that office who has a clue where anything is.
Yeah, Cumberland County is not a lot better, at least in this septic department.
Yeah.
Excuse
yeah,
me,
that's
environmental health. Don't go looking for the septic department. You won't find it. It's under the environmental health.
This is why I love New Hanover County. You just email them and whoop, an hour later it's in your inbox. I'm like, oh, this is fantastic. So yeah, but definitely whether you're a buyer agent, seller agent, pulling that septic permit can save you and save your client. So definitely do it. And remember, you can only advertise the bedroom count for the number of bedrooms reflected on that septic permit. So. And then this one I'm sharing with you because this one was interesting. Again, hats off to Debbie. Lindsay was listing these properties and Debbie decided to pull the septic permit. And when we pulled the well permit, so if there's a well, you're going to want to call environmental health and get that well permit or the water department. The well for this lot they were trying to sell sat on another lot altogether. So if we hadn't checked that, and somebody came in and bought lot 6 and someone came in and bought lot 7, lot 6 in theory could cut the water off to lot 7. So you have, if that ever occurs, you got to get on the phone with an attorney and figure out what can we do. It might just be a situation where we do an easement agreement or some kind of agreement between the parties that survive and continue on past closing. It might be trying to relocate the well. It's just talking through what are your options. But if she hadn't pulled this and just said, oh, it's well water and we know they have a well and they're good to go and moved forward, we could have been in a lot of trouble as a brokerage, you as an agent, and the seller too. So it's rare that stuff like this happens, but weirdly, we could, Michael, I know Thomas, have you been in business long, Thomas?
No, this is I'm just wrapping up my first year.
Congratulations. I know Tony, I think Tony, you've been in for a little while, right?
Oh yeah.
So yeah, so between Tony,
Tony's
Lauren,
my queen of the world's most interesting situations.
like, we could write a book. We could get together
Tony could write a good one, I promise.
over margaritas and write a book of the weird stuff that real estate pre-licensing classes never teach you. So
I could say I've had one listing, but it was not at all typical, and actually I had to withdraw the listing. It was a home that my seller had bought at a foreclosure, like a courthouse auction, and he bought the house and tried to get it on the market as soon as he could, and actually we were actively listed, and the foreclosed previous owner filed a series of frivolous lawsuits. Like, they named everybody. They named the Secretary of State and the judge in the foreclosure proceedings. They named everybody, including the owner, the current owner, who had a trustee's deed. And we had to withdraw the listing because there's 2 clouds on the title. 6 months later, so he's got a house that he can't sell.
yeah.
Once it goes to litigation, it takes forever. It ties everything up. And that's sometimes the intent of that.
Yeah. So it's actually he never wanted to live in the house. He bought it as an investment, but really, like, he had to occupy the house just because he was afraid that they were going to occupy the home. And so, yeah, he ended up having to move into the house and still waiting to hopefully this month he's going to have it ready to list again. So that'll be my listing again.
Yeah. So we could write a book about just crazy stuff. If it's crazy, it's happened. So, but pulling the septic, pulling the well permits, any permits within the county, you're going to pull. And so do a permit search. That's the other thing I would say too. Do your permit searches, make sure there's no open permits. or repairs. If you go in and they say, Thomas goes into a listing appointment and the seller goes, oh, Thomas, you're just going to love my house. I've completely gutted it down to the studs. We've rebuilt everything. It's like a brand new home. That should trigger in Thomas's mind, I got to do a permit search. I got to make sure that the work was done to code, that it was permitted. There's no open permits, because open permits can cloud a title to and stop closing. So you're going to want to call
Caryn,
them. Yes.
can you hear me?
Yeah, Debbie looks like she made it to the rapture with that blue light going on.
So I just want to mention something about this particular property where the well was on additional lot. If I had not checked the PID numbers for all 3 lots, because they were going to sell these lots separately, go back to this page. They were going to sell the lot with the house, which is lot 7. Lot 6 is where the well was. And then they had this other lot, which was just a sliver of a lot. And if you will see the PID number for the house, the PID number for lot 7, 6, and then for this other lot, the attorney, this was bought out of foreclosure. And the attorney that did the foreclosure did not appropriately assign the PID numbers. He messed them all up. Had I not checked every PID number for each lot, even though they were going to sell them together, I would have never found this situation. So if it's multiple lots, and it was a house bought out of foreclosure, you need to search your deeds back. I had to search back to the very original where this was platted to get the original PID numbers and move forward to find all of this information. So it's just be mindful that you need to check every PID number when you call the environmental health. Otherwise, your septic may be on one lot and your well on another, as it was in this situation.
And having a different PIN number, that's rare, but it can happen. So that's why looking through the tax records helps. And then common special assessments. We're asked in the listing agreement if it's subject to any special assessments. There are HOA special assessments that you can see. You would call HOA management companies and just ask them, do you have any potential pending or confirmed special assessments we need to deal with? Sometimes towns and municipalities will have special assessments for road grading and things like that. I don't see the tax office and the town municipalities having special assessments that often. They're rare. They can happen. Most of the special assessments I see are from HOA management companies. So just you have to verify all of these and asking the seller questions. Hey, have you had any governmental and have you had any notices from the government about violations or anything along those lines, or any potential special assessments coming from your town or municipality or your county? Yes or no? HOA management companies, have you had any of these? And ask them. But HOAs, they're a little harder to verify, so they get a little tricky and get a little. I know down here in the coast, they're harder to deal with. I don't know about ever elsewhere, but
It's hard to deal with.
yeah, I'm not a fan.
Yeah.
Zoning, we're required to confirm zoning for each property. You can contact the zoning office and ask, but like Lauren said earlier, interactive GIS maps. So if you search Wake County GIS maps, it should take you to that website where you address of the property, and it'll give you all kinds of fun information about the property. And then down there at the bottom, flood zone maps can be found that's a website that you can go to. It's fris.nc.gov. And if you enter the property address, it will tell you the flood zone of the property. What I always do with the zoning and the flood zones, I print those maps and I put them in my .loop. That way, if Lauren were ever auditing my listing file, she's going to see where Caryn went in and verified the flood zone, where Caryn went in and verified the zoning. I even do it for school districts. Brunswick County is a harder school district to verify. New Hanover is super easy. I just go to New Hanover County Schools locator and it will find my school by my address for my students. And then if you're dealing with a manufactured home, how many of you guys have manufactured homes in your marketplace?
We do.
Yeah, they're big in the South. So manufactured homes, these present, if you're ever going to list one of these are questions you have to ask. Is the home affixed to the property? Is there a title to the manufactured home? Have the wheels, axles, all of that fun stuff been removed? And is there a HUD plate? It's amazing to me that lenders, appraisers, all of them require the HUD plates. And the second someone goes in and remodels, that is the first thing they remove is that dang HUD plate. Michael, the last time we taught this, was kind enough to share that website that's across the top, that LVR2. It's IBTS. It allows you to search manufactured homes. Not all single wides are eligible for lending products, and neither are double wides. So you have to be very careful knowing this information.
You don't advertise like you can get a FHA or
Or
VA loan, because more than likely, probably not.
right. So mainly cash and conventional is what I see on manufactured homes. If there is a title, if the seller's like, yep, I have the title to the house, it's like a car title in North Carolina.
Mhm.
So when you're, even if it's sitting on a lot that the seller owns, so at closing, the seller has to sign the deed for the lot itself and then bring that original title and sign that over to the new buyer. And also not every attorney does manufactured home closings. Michael, is there something you want to add?
If they're using a loan, I just ran into this. I'm selling a manufactured home right now. And if they're using a government loan, they require a foundation. And the engineer that went out to look at it said that it needed these pillars put in and it needed a vapor barrier put in. And he had 4 things that it didn't fit. And I've dealt with this particular guy before. He reads the regulation and says, this is the way that I want it to be, not the way that it's required to be. So make sure you know somebody that can go out there. Foundations Plus in my area and the guys that can go out and tell you whether or not it's correctly on a HUD certified foundation, which is required for a VA or an FHA loan.
It's not impossible to get lending, but if I'm listing this, I'm not gonna, without having that like Michael said, without having that foundation certification, I'm not gonna advertise it as the listing agent for a VA or an FHA loan. If your seller's like, I want to list it for that, then you've got to go, Mr. Seller, are you willing to incur the cost to have that certification when we list? That way we know the foundation meets VA or FHA requirements. If they're not willing to do that, and do you know about what the approximate cost of those are, Michael? I think they're about 600, but I don't quote me on that.
800, I think.
My guy just charged us $450
Okay.
for the letter.
So if that's something that's a charge your seller's willing to incur, and having that in hand at time of listing, I would be more inclined to list at that point that it's eligible, but they're a little bit more tricky to get through a government loan without having all of those boxes checked. And if you advertise FHA or VA and suddenly the foundation is not on that government approved foundation and the seller's like, no, I'm not doing anything, you could be at risk for, misrepresenting a lending product on a home. So, any questions on manufactured homes? And then this one I'm using as an example. This one actually went to the real estate commission and the agent got fined, and the agent was a broker in charge for a local Wilmington company. She advertised this house. It's a manufactured home. She advertised the year built 1991. When we pulled the building details, the age of the home, it was like 1989 or 1980. So it was at that point, the lender wouldn't lend on it due to the age of the home. And we already had an appraisal in hand. We already had home inspections completed, all of that stuff. And all the buyer asked was to be made whole. Just refund my earnest money, refund my due diligence, refund all of my inspections, make me whole, I'll walk away. And the seller and the listing agent were like, no, I'm not going to do that. You're talking $2,500. Neither one of them would do it. At the end of the day, she asked what her legal options were. She went to the real estate commission and she got her $2,500 from the agent. So just verify. If I know this is a manufactured home and I pulled the tax bill and I see 1980 versus 91, and it was an honest typo. I'll be honest with you. It was an honest typo on that agent's part. But when she discovered it, she didn't correct it. And she didn't make the seller whole. I meant the buyer whole. We're responsible for everything we input into that MLS. So taking your time on that as well. And then that's pretty much all I've got. This is just kind of a rough proposed timeline to attending the listing presentation, things you have to verify. Stage 3, you get that listing agreement signed. Stage 4 is when you do all your fun scrambling of professional photography, measurements, input your information in the MLS, upload your documents. And step 5, get it listed for sale and get it sold. So
I think Caryn kind of made a good point real quickly to talk about, you have a second, is that there, as you can see from this lovely past hour, there's a lot of information to verify, look up, go through, depending on, the parameters, like if it's manufactured, if it's on well septic, it doesn't have an HOA, all these things. There can be a lot of information that we are responsible for verifying, looking up, and all that. Honest mistakes are going to happen. We're humans. I think the key is in the real estate transaction, if that does happen, it's, admitting that, oh my gosh, you did make the error, doing what you can to correct it. That will save you. That could possibly keep the deal together. Or if it doesn't keep the deal together, it can keep you out of real estate jail. And just understanding that, okay, now that you've been made aware that this was an error, you're correcting the listing, you're updating disclosures, and all those kind of things moving forward if you put the home back on the market. Where I see a lot of agents getting in trouble, like Caryn said, is where they refuse to kind of back down to that buyer. They don't admit, hey, we're so sorry, like it was our mistake. And then especially if they relist the property and don't make any corrections on the new listing or disclosures, that's where they're going to come get you. Like I said, you're going to do it at some point. We're all human. We're going to miss a little something, and that's okay. It's just all about working with, ethics and integrity to do the best job we can within the information presented to us, and say, hey, we're so sorry. We had and it could be that you really truly had no way of knowing it till it was discovered through inspections or title searches and all that. But then, okay, how do we move forward? How can we make it whole? If it's, it really truly, we thought it was a 4-bedroom septic, is only 3, like talking to your seller and explain to them, like, you really just probably need to come down the price now, because if we relist it, we're going to have to go in as a 3-bedroom home and just the price. So helping your seller also understand, we now know these items and it's going to affect it if we have to relist it. And if you, Mr. Seller, don't want to disclose it, okay, you don't have to, but I do as a real estate agent. I have to disclose these things. So just kind of working with your clients on both sides. And at the end of the day, we're all trying to get to that win-win. So just don't ever be afraid of this thing. Sometimes admit, okay, I'm so sorry, I made a mistake. How can we make this work? Or how can we work through this? And I think a lot of times you'll find people are willing to work with you if you come from that perspective versus just nope, not happening.
And Lauren brought up a good point. If, say, you have a listing, you get a home inspection report, it's to the seller now has material facts they did not have when they first filled out that residential property disclosure. Your job as the agent is to encourage them to update their residential property disclosure to reflect what they now know. That doesn't mean that they have to, they don't. But the real estate commission is going to ask you, did you ask them to do it? Did you encourage them to do it? So I would have that in writing. I would have that in an email form, and then just uploading that email, print that email, upload it into the loop. I had one time, seller told me their fireplace was plumbed for gas. We got all the way to the day of closing and I disclosed it was plumbed for gas, and they got all the way to the day of closing, and the buyer's like, it's not plumbed for gas. And it was like a $600 fix. And I'm like, that was my fault. I misrepresented it. I'm going to get the gas company out there. I'm going to pay out of pocket for it just to keep the deal together. She terminated the contract because the fireplace wasn't plumb for gas and lost $5,000. There was more to it than that. But if she had went to the real estate commission, they probably would have slapped me on the wrist, but I had written correspondence where I said I owned the mistake and I offered to make what I advertised, offered to give her what I advertised at my cost, no impact to her. So I think the real estate commission would have scolded me and moved on
And
about.
that's what you see if you read the bulletin, you'll usually see, and they will say like this, the agent made no effort to make whole the other party or disclose. So that's where they're really coming in on is like, okay, did you learn from this? What did you do to try to make the situation right, to try to make it right, or learn from it, or disclose better? And then if you don't show that, that's where they are going to come for you. And even, you know, like you said, could avoid the whole process because the buyer feels like, okay, it was an honest mistake and you really are in earnest are trying to make them whole.
I have a
And if you're-
question.
Yeah.
While we're talking about property disclosures, my current listing, my seller has no idea how old the roof is.
Mhm.
I went and looked back at previous disclosures from when it was sold in the past, and I found 3 different disclosures, you know, the 3
Yeah.
consecutive sales where they said per the previous owner
That's-
when the roof was replaced. So I haven't updated the property disclosures because it's hearsay, but I have said when agents have reached out like, hey, do you know what the age of the roof is? I've said per previous disclosures, they have all said per the previous disclosure. So I can't guarantee you that this is the age of the
And
home.
you don't know because the other sellers fill those out, so you don't know if that information is even valid. So that's, and I
Right.
think that's all you can do. You can only
Okay.
disclose what you reasonably know.
Right.
You're not a roofer, you're not a contractor, you're not looking up there. So
Because the home was built in like 1986. So if there's a chance it was replaced before 2010, great.
Well,
But
and
I
it might-
can't guarantee that.
right.
I asked the seller, look, call a roofer that'll do $150 roof inspection. We could get that and upload it in document. I mean, it's just an option.
Yeah. Yeah.
I wouldn't, and I'll be honest,
The seller has been very unwilling to do anything to improve the status of her home. So,
and I
that's
will
okay.
say, if you put per previous, you're still probably as a seller or as an agent going to get slapped on the wrist.
Well, and we don't have anything. We have,
No, I know.
I think,
I know, yeah.
yeah.
I think and sometimes that's okay. If you truly don't know, you don't know. And that's an
Yeah.
okay answer because if you then try to guess or I think this, that's we can also
Right.
actually open ourselves up to a can of worms
Right.
versus just saying, we don't know. And so
And that's why,
we
like,
don't
when
know
I've disclosed, I've made it very clear, like, this
Yeah.
was per a previous disclosure from a previous
she bought it in this
sell.
year, she's not done it.
Yeah.
So it's either sometime between when it was built and 2010.
Yeah.
We don't know.
But if I can avoid you deducting $20,000 from your offer, I'm gonna try and do that and let you know it's not a 40-year-old roof.
And Lauren brought up a good point. We are so eager to be helpful and we want to be helpful for our sellers and potentially to get the home sold, but don't be so helpful that you open yourself up to something because everything we say, weirdly, and I'm not trying to scare you, I'm just trying to keep you knowledgeable. Everything we say, someone could try to turn against us. So if she had said, oh yeah, it looks like from what I've done in my research, it was 2010. And they come in and say, oh, well, no, it's not. It's 1984. They could say, well, Megan, you told me 2010. I relied on your 2010 and your research. You're the listing agent. What are you going to do to make my client whole? You're going to refund the due diligence money. The other thing Debbie put in chat too is if you're doing a manufactured home, know that wind rating. Because it's got to be wind rated to a certain extent, especially here.
Oh yeah, for the coast, yeah.
Yeah, so if you're on the coast, know your wind ratings for that on a manufactured home. And
But
just
yeah.
when in doubt, lean on your BICs, lean on your closing attorneys, you know, those relationships you have and ask those questions of your seller.
Yeah, you're gonna have crazy situations. I mean, heck, Tony's had to get a POA signed and had to, I think, visit a jail or prison to get it signed because the person who owned the home was in jail or prison and was signing it over to their father to orchestrate the sale. We do fun things as real estate agents.
Yeah.
had to
So-
send an attorney into the jail to have him sign it, to get a quit claim deed, because but he didn't purchase the home. His father had purchased it for him, but the deed was made out in his name, which it should not have ever been made out in his name under those conditions, but
Oh, never a dull moment.
But yeah, so, well, I am going to stop.
No questions, and I think we're